You wanted time. What is it about? You are arguing, very good. No, you are very good that you are arguing. That is what it is. What do you want? You want what you are showing?
Page number 376.
370.
It shows the documents where a unique array of different starting papers are saved. Multiple copies with the same unique ID.
Page
376.
370.
Documents are multiple numbers. Same unique ID there are different starting papers. Furthermore, Aniksha R. These are the stamp papers which were being sold by respondent number 23 association. In view of the application that people made to get electricity from the ESCOM, in each of the applications, there are agreement forms, indemnity bonds, which are to be Annexure R numbers. If you see the KP Chalan number, Annexure R numbers, page number 332. If you see the KP Chalan number, 0923.
Page?
Page 332. Volume 1. Sorry, volume 2.
Only repeated 2 copies are there of each certificate.
Yes, that is Annexure R.
No, this you are showing page 376. You showed page 376. Annexure B. Then there the certificate numbers are same in respect of there are two same certificates. Now you are showing what? B.
Annexure B.
V. Then?
In Annexure R numbers, these are the old stamp papers which are sold by respondent number 23 association with the application forms which are to be issued to the ESCOMs for connection.
Which page?
332 numbers.
332. So application form number 43870.
The entire K2 Chalan number that they printed in the documents in itself proves that the documents are counterfeit numbers. I'll establish how numbers. Every K2 Chalan number after the alphanumeric, that is CR, represents year and month number, month and year numbers. The 05 indicates the month in which the said Chalan was generated, and the next two digits numbers, that is the 5 and 6 digits, they represent the year numbers. In spite of that numbers, here the K2 Chalan numbers that have been printed on the said documents in the name of Sub-Registrar Mysore South numbers clearly indicate numbers. Like all of the 10 documents that are produced in Annexure R have Chalan numbers which are not even valid, which have been checked and produced before this court in Annexure S numbers. They have been checked. The Chalan numbers are searched on official Karnataka government website, wherein the Chalan search shows that no results found. In spite of this malware, there are millions of copies of such documents which are lying before the ESCOM's malware. The Shirap police station has taken this matter and has filed an FIR malware. They have seized approximately 19 to 20,000 copies of these counterfeit documents which have been produced before ESCOMs. And the same is obtained through RTI. The petitioner is a journalist who worked as a photojournalist for the Hindu. The entire matter started from 2002 when the license was granted to this respondent number 23 association. There has been misappropriation of public funds, hence a request for a short accommodation so that senior can argue the matter in detail in any day next week. in spite of giving multiple representations, my lord, by annexure X to X19.
System generated. Very vague.
Annexure R, my lord. They have issued multiple copies of the same, with the same challan number, my lord. They have issued multiple copies of the counterfeit stamp papers, my lord. And in violation of section 10A of Karnataka Stamps Act 1957, which directs that each of the instrument which is taken should have separate K2 challan, my lord. K2 challan number should be separate, and for the exact amount to which that instrument is printed. The sub-registrars, my lord, across the state have been depositing amounts in lakhs together and are issuing such kind of counterfeit documents. Such kind of documents with the same numbers. We don't know how many approximately can't calculate numbers as to how many number of counterfeit documents are already in the society. The entire legal sanctity of document, the sanctity and legal document process is compromised in this. It can be called as another tail.
Now you read your page 4. Your facts, read your facts. Second paragraph. Paragraph B. Read it. Brief facts लिखा है, page 4. Then paragraph small b.
Generation, transmission, distribution, trading, and use of electricity in India is governed by provisions of Electricity Act 2003. Part 6 of the said Act, inter alia with distribution of electricity under the said Act. Electricity generated by a generating company in a generating station and supplied to a distribution licensee under section 43 of the said Act. Every distribution licensee is obligated to give supply of electricity on an application of the owner or occupier of any premises within a month of making such application. The applications to apply for such supply are provided by the distribution licensees, that is ESCOMs, in a prescribed format and free of cost to the consumers. And also same have been made available online in the websites of the particular ESCOMs. Further, in order to seek transfer of installation, the consumers have to make an application to the ESCOMs as provided for under clause 36 of AERC conditions of supply. These applications seeking power supply or change of installation have to be submitted to the ESCOMs along with agreement form and an indemnity fund. Respondent number 23 association named Karnataka State Licensed Electrical Contractors Association, Bengaluru, which claims to be welfare body of the licensed electrical contractors across the state of Karnataka.
The grievance in this public interest petition and the cause sought to be espoused is that there has been a large scale irregularities committed in counterfeiting the stamp papers from illegal, doing the franking illegally and selling the stamp papers unauthorizedly. The legal documentation is tinkered with and the false applications are generated, it is alleged. Paragraph. Learned advocate Mr. So-and-so invited attention of the court to Annexure V to submit that the stamp paper bearing the same certificate numbers are surprisingly found in more number of copies bearing identical certificate number with reference to full stop. Annexure R, also it was stated that the challenge numbers are fabricated. Fabricated challenge number indicated on the what? On the agreement. On the stamp paper on which the agreements are executed. Full stop. At this stage, the court deems it proper to require learned additional government advocate, Srimati Neelofar Akbar, who appears upon service of copy of the petition in advance, to look into the issue and apprise the court about the facts. Stand over to 24th October.
Or black.
Yes.
Cell number 16.
What is this Indira canteen?
It is the project of the government, where a food canteen is proposed to be set up.
So today at this place, school is running.
School, it is 100-year-old government school. In that premises, now they want to bring down the building of the school and set up an Indira canteen in the said premises. In fact, Annexure A, it is a government high school, which is running for the past 100 years. It is in the center of the town, Malebenur town, which is
Which is the town?
Malebenur town, within Haryana Taluk, Davangere district.
The school is running since
Since the past 100 years, the school is running.
secondary school.
High school, please.
High school.
High school. Annexure A, is the circular of the government, If your lordship kindly peruse page 33, The government itself, has given instructions, that the land which is, belonging to the educational department should not be deviated, to any other departments, for any other purposes also. If your lordship kindly peruse page 33, May I read, subject regarding the transfer of land related to government schools to other departments. With reference to the above subject, land or plots were previously donated to the government for primary, secondary, and pre-university colleges by benevolent donors with the intention of benefiting the schools. Now there is significant need for the land to construct buildings, playgrounds, and compounds, as well as to provide various other facilities for many schools. Additionally, there are several examples of plots and land located in central areas of the cities. Creating a conducive environment for children's education has become extremely necessary in the current scenario. However, many departments and organizations are submitting proposals to the government through their respective departments to transfer land or plots belonging to the education department for purposes such as constructing buildings, creating stage pavilions, establishing bus stations, and so on. Due to such requests, there is a concern that in future there may be no land or plots available for education departments. Therefore, it is hereby instructed to identify and acquire plots from other departments in place of those belonging to education department for any future needs, and to take necessary steps at your stage and instruct them in this regard. This circular, is issued, by the respondent government department, the Annexure B, is the resolution, of the committee, school committee, that if your lordship kindly peruse, page 37, In fact, they have objected, they have passed a resolution, objecting to such proposal, for construction of Indira canteen. Page 37, Annexure B, This has been brought to the notice, my lord, of the Deputy Commissioner, my lords, third respondent authority, my lord. And my lords, annexure E at page 47 also, my lord. The Deputy Director, my lords, of the Education Department has addressed a letter, my lords, on 25th of January 2024. To immediately, my lords, take steps to stop, my lords, the proposal for construction of Indira Canteen. At page 47, my lords, is the letter, my lords, of the Deputy Director. Annexure E, my lords. At page 48, my lords, the last paragraph is relevant, my lord. Page 48, my lord, the last paragraph, may I read, my lord.
The school is the Devanagari.
I'm sorry, my lord.
School is located where?
Malebenur, my lords.
What is it?
My lords, it is my lords, it is within Davangere district, my lord.
Malebenur.
Malebenur, my lord. Lord, in fact, the circular of the government, my lord, which I have produced, my lords, at annexure H, my lord, page 63, if your lordship kindly peruses, my lord.
So condition of the building is,
My lord, it is a old building, my lords. However, my lords, there is a new building, my lords, which is constructed for the purpose of the school. That is also, my lords.
old building is in good condition?
I'm sorry, my lord.
Existing building is in good condition?
It is in good condition, my lords.
How
There
do
are,
you, how
my
do
lords,
you say?
there are two buildings, my lords, within the government high school premises. The old building, my lords, it is in a dilapidated condition, my lords. However, my lords, within this very same premises, my lord, there is another building, my lords, which is already put up, which is running, my lords, for the past 10 years. In that building, my lords, the school is functioning.
What, the earlier building is not used?
It is not being used, my lords, as of today.
So
But the
then-
proposal now, my lords, by the Deputy Commissioner is to, my lords, demolish that old building and to set up an Indira Canteen, my lords, in that place.
My lord, could I make one request? My lord may have this on the 26th. My lord, I will just get oral instructions, then I leave it to my lord.
Yes, you notice.
Oh.
The heard learned advocate Mr. So-and-so for the petitioner. The
I appear for
grievance
all
raised
the
and
respondents, my lord.
grievance raised and the cause espoused, and the cause sought to be espoused in this public interest petition is that in the premises and in the compound
Please, my lord.
of the
Government, my lords, at page 18, my lord, last
what is
line.
that name of the
My
school?
lords, page 18, last line, my lord. Government Model Higher Primary School, Malebenu. Page 18.
Of the compound of the
Page 18, my lords,
page 18.
last line.
Government Model Higher Primary School, Malebenur,
Harihar Taluk, Davangere district.
Harihara Park, Devanagari district, which is comprises of 100-year-old
Please.
school building and the new school building. The respondents are proposing to set up a public canteen under a scheme by demolishing the existing structures of the old school as well as the running school.
My lords, the old school building is proposed to be demolished. The new school building is, my lords, as it is running.
By demolishing the structure, full stop. Notice returnable on, say, 21st of October.
Lords,
Obliged.
may I request, my lord, let them not take any further steps, my lord, in
No,
terms.
my lord, I have taken notice.
Please, please.
If something is happening, come.
Great.
You are accepting learned additional government advocate. Srimati Neelofar Akbar accepts notice on behalf of respondent
1 to 8, my lord.
1 to 8.
9 notice will have to go.
6 is the chief officer.
Huh? I'm sorry, my lord. 6 is my lord, for 1 to 1 to 4, my lord, 7 and 8.
Up to 4 you are appearing.
1 to 4, 7 and 8.
1 to 4, 7 and 8. Most of the rest of the respondents
Yeah.
will be served. Correct.
Number 17, Mr. Sachin BS. Please.
Written submission, but I'm filing on behalf of the central government.
Sir.
So this structure is in regulated area.
Yes.
So any application is filed?
No. Hello, application failed for grant of NOC.
Twice they have, twice they have rejected
Oh, no, they gave the application after commencement of the work, therefore we did not entertain.
Have you got, Mr. Kamath, the order dated 21st June 2023?
21st June 23. Lord, I have it before me, my Lord.
So.
That's a direction. Huh?
Yes. Yes, we have also filed.
This many has said. This is the order. Paragraph seven.
Lord, I have a copy of the order.
Got the copy.
Yes, Lord.
Paragraphs. Paragraph
seven.
Seven.
Para 7, Lord, in view of the above referred facts and submissions of the learned senior counsel appearing for the council, we deem it appropriate to direct ASIs to consider the application submitted on behalf of the Chief Officer, Town Municipal Council, Mudbidri, afresh in view of the provisions of Section 20D3 stipulated under 20D4 of the Act. The ASI shall also file an additional affidavit with regard to the proposed steps in view of its own report submitted to the court. Pursuant to this order, my Lord, we rejected the permission sought by the council by an order dated 28/7/2023 on the ground that there is no provision to give an approval post facto.
28/7.
28/7/2023. Lord, under Rule 34, of the ancient monuments rules.
Then how do the court get out from this rejection?
But if your lordships directs us to, by condoning the delay, if your lordships directs us, then we'll do. But on our own, we cannot do because it will be contrary to the rule. If sufficient grounds are made out by the council before your lordships,
So we can direct by interim order
any direction, even if it is interim in nature, my lord.
to consider the entire issue afresh in light of this last report.
If your lordships would say consider on merits,
Merits.
condoning the delay in filing the application for approval. Not the,
Who will file the application?
Municipal council.
the municipal council ought to have filed the application 3 months prior to the construction. So there is a delay in filing. So if that delay is condoned, my lord, then I would take a decision on
That
merits.
delay is condoned and the fresh application may be filed.
Yes, yes.
So intake report is what?
I'm sorry.
INTACH.
INTAC it's a body to protect heritage and.
So
ancient
that
monuments.
report is favorable to.
Yes, yes. INTAC has also said it will not affect the ancient monument in this case.
हमने देखा था ना, we had seen that.
It is based on INTAC report, we filed an affidavit saying that it is not going to affect the monument. Lord, our pleaded stand is that the proposed construction will not affect the monument.
So in light of, you have accepted the report.
Yes,
So in light of that fact that you accepted the report
yes,
and further considering the attendant merits, you decide it.
yes.
Because it is.
The delay in filing the application, if it is condoned, Lord, then we'll proceed to hear it on merits, take a decision on merits. The application is condoned. And if your lordships directs us to consider it on merits, then we will take a decision and communicate.
Delaying filing the original application.
Yes, because as per the rules, they should have filed it 3 months prior to the construction, but they
We
filed
can-
it after the
We
construction.
can say press application.
Yes,
Instead of,
my lord.
instead
Lordship-
of going into the
Yes, my lord, lordship made.
press.
Yes.
It will be treated as.
Yes.
It will be entertained.
Yes, my lords.
Notwithstanding the rejection.
Further delay. We have already filed a writ petition. Proceeding the rejection order. Therefore, the very same application can be considered.
Condoning the.
And only because.
But only we are thinking, why should we even give a go by to the limitation aspect? On the contrary, we'll say that notwithstanding the rejection, it will mean the same thing. But approaching the destination.
The
different
result will
way.
be the same, everybody. Result is the same.
They should not further say that.
No, their lordship, I mean, the honorable court will direct us to consider on merits.
We'll consider both the options, let us see. We are posting it on next Friday.
Yes.
For
And also-
orders.
Please.
So we'll just show all of you the operative direction so that anything to be suggested, you can
Please.
suggest.
May I add one aspect, my lords? Your lordship is considered that whether rejection is proper and that can be condoned and permitting, my lords,
Yeah.
whether they can permit it, etc. is, my lords, reconsidered, my lord. As far as that aspect is concerned, I bow down to whatever my lord lays down. But my lord, as for the legality of the tender process, how the land, valuable land is given to the contract, as far as the, no, let me complete, please. I'm stopped repeatedly, my lords, because there's.
Tender process will be touched there.
My lords, may I submit this, my lords? Now, as far as the municipality filing an application, getting permission is one aspect.
We are not deciding which may have affect your tender petition.
My
We are
lord,
only requiring them to decide afresh.
Even the tender process has to be, my lord, redone again. Because tender process is on the face of it is
He has
illegal.
nothing to do in the.
They want to
matter,
take
my lord. He is a
advantage of
fifth
that
party.
and then say it's rendered infructuous.
He is a
that
third
cannot
party,
be
who has
done.
nothing to do in the
May-
matter.
No, this is based on the tender contractor. Now, the
Tender is an
contractor,
independent, separate
let me
proceeding.
complete it, please, with kind permission. The contractor, according to us, my lords, joined hands with the municipality. That's why both of them are
Sorry,
together and saying
This kind of
construction.
allegation
Let
is
me,
being made
I don't
repeatedly.
know. Because in a public interest litigation, when something is put forth, contractor is interested in seeing that that is not brought to the kind notice of the Supreme Court. I made a short note, my lords, on the tender process. On the face of it is like the government is giving away a valuable property without following any law.
You're not
You
giving-
may I pray your lordship to synopsis which I have filed, my lords. Synopsis filed in point 14829.
Lord, that
It's already-
tender matter can be decided separately.
No,
Let
this
this
is the
be
thing which-
decided first, because the tender issue, my lord, is an independent, separate proceeding. That we
Unless
will
it's
argue.
decided-
There is no
Unless
difficulty
the
about it.
validity is decided, he has no right to, the municipality or the contract, no right to say, I will go on with the construction. Your lordship may kindly permit me to go to
That's
two
correct.
lines.
You are right.
Please, my lord. Now, my lords, the tender process is illegal. How the process is given? I have absolute no objection, municipality getting a construction, valid construction.
We'll deal with the tender separately.
Please, my lord, only prayer is, my lords, kindly safeguard the interest, my lords, in the validity of the tender, my lord. Unless an entity is upheld, they
You have-
cannot,
You have still at least one date to argue on 26th.
most of it, my lords. I'm grateful. With the patience with which honorable court dealt with the matter on Saturday, we are grateful, my lords. A short synopsis I have provided, my lord.
Permission.
Synopsis.
Officer inform, ಹಾಕಿಲ್ಲ.
2-3, please. 2-3 dates I mentioned the synopsis.
Now, Mr. Kamath is there? Yes. Where is that earlier rejection page?
Madhu.
You got it? The application.
Yeah,
is-
the first rejection was in 2019.
That is, the earlier rejection is challenged by the municipal council in a separate writ petition, my lord.
No,
that-
it is dated, rejection is dated what? That's.
The
19,
rejection date is
2019.
I'll furnish the date.
and
It
the
is
page,
16/9/2019.
16/9.
2019.
16/9/2019, challenged in WP 51844.
28/7. Huh? Oh, that is 28/23
28/7/2023 is the second rejection.
pursuant.
That is pursuant to your lordship's order on
21/6.
21/6/2023.
Both on identical grounds.
So, we will find this on which page?
In my written submissions, my lord, it is page 6 and 7.
Written submissions में है दोनों,
Today, what I have filed today,
दोनों,
dono,
both.
page 6 and 7,
page,
6 and 7.
It's my duty to bring to the kind notices one aspect, my lords. The construction started despite the notices issued by the ASI. Don't go proceed with the construction. The contractor proceeds with the construction despite the notices. Serial number 11 in the synopsis I mentioned, my lords, that we are going to take penal action ASI stated. That is on 18/1/2018. Despite that, they proceeded with the construction. Now, my lords,
actual order for that. We need actual order. Give the page to
Yes,
learned
yes,
court.
Yeah, I'm sorry, lord, I will furnish it.
Page of the actual order.
Yes.
On
Oh, I'm sorry, lord, I thought it is the written.
please.
But we
This
are also-
conduct, my lords, that despite the repeated notices issued, they proceed with the construction and they rely upon an
That is
illegal
not
tender
correct.
process
That
to
is not
give a
correct.
land to a contractor.
That is
They
not
don't
correct.
want me to submit this because that I beg to submit if the honorable court comes to know how the illegality is committed in the,
No, we will be able to
Tender process.
justify. We will be
This-
able to justify the
You-
tender
you
proceeding. Let
generally
us
this-
argue the matter.
generally the indulgence may usually be granted, but in the present case, my emphatic submission before my lord, have regard to the contractor and the tender it's in which it's given. Construction carried out despite the notices and the tender process itself is being illegal. I beg to submit tender process has to be set aside. Then everything can be done, redone again. Then they can file an application,
This
not
is
on the basis of this illegality.
build,
They
operate
wants to,
and
my lords,
transfer. It is
taking
our
it
own
to-
building.
Then let me complete. I don't know why. Tender process, my lord, is still being illegal. Construction being carried out after the legal notice issued by the ASI to stop the construction. Despite that, they have no respect for law. And the tender process itself is utterly illegal. No procedure whatsoever is followed by giving a valuable land. Valuable land is got by the tender, the contractor, he proceeds. No process is followed, my lords. Therefore, I beg to submit when the honorable writ court is exercising the jurisdiction and granting some indulgence, that cannot be by a person who comes to the court without any clean hands. He suppresses everything. There was series of orders. Statutory body violates it. At the instant, the contractor, he is a beneficiary. Now the statutory body wants to help him, not to the public. A prime land is given to the contractor.
That will deal with separately.
Please, only my fear is, my lords. Now the beneficiary will be the contractor who has corrupted the municipality. This every process,
Lord, may
I
I
use the
make
term, is
submission?
by corruption.
It is a case of it's a case of build, operate and transfer. Building belongs to us. He is expected to
Please.
build it and transfer it to us. It is not a case where we are transferring the property. He will operate for 15 years, transfer it to us. So it is our own building. Yearly rentals will have to be given, that is all.
What is the process? Tender process? No tender process. They give it to one person within 77 days. Single person.
Tender aspect will.
Two
That's a very,
bidders are
very,
there,
I
he
feel
is
if
making
my lord
incorrect
gets
submission.
to the file, how it's given, your lordships had on the earlier occasion summoned it. If the state government produces that file,
Lord,
that
I
will be
found
totally
both the-
shocking.
Both the page numbers I can furnish now, would your lordship?
Rejection.
Make it- Of the rejection. Lord, I found the page number and the annexure number. Lord, the first rejection, that is 16/9/2009, is at
नहीं नहीं मुझे you-
annexure G in WP 51844.
नहीं, पूरी file.
Yeah, got it.
You do complete. So first rejection.
First rejection, your lordship will find in WP 51844 of 2019.
51844.
Yes, lords, of 2019 at annexure G, page 23.
Page 23,
Annexure G, page 23, lordship is right.
which is dated
16/9/2019.
19 years. And second rejection.
The second one is filed by us in the same writ petition, filed by respondent 1 and 2, along with an affidavit presented on 4th August 2023. Along with that affidavit, it is available at page number 4.
That is in which petition?
In same writ petition, my lord, that is
Same petition.
51844. The respondents 1 and 2 filed an affidavit on 4/8/2023, and along with that affidavit, they have produced it at page number 4. A communication dated 28/7/2023.
20?
28/7/2023. That is the second rejection. Both are in the same writ petition, 51844.
I was trying to point out the conduct, my lords, that there was a direction in serial number 11 only in my synopsis. I pray the honorable court, serial number 11 in my synopsis, where legal notice was issued, notices were issued to stop the construction. And they did not. No applications filed. So all these applications were rejected, my lord, by a reasoned order. A fresh application can filed. These previous applications were rejected on account of certain reasons, and their conduct desensitizes them to say that let the previous application be considered. They can file a fresh application which can be considered in accordance with the law. Otherwise, it amounts to, my lords, getting incentive for the.
Will consider.
Yes,
Please.
my lord,
Please.
my lord, he is not appearing in those
Yes, I am the public
petitions. I
interest.
don't
Please,
know
please.
why he is making
Yes.
submission. My learned friend, senior counsel is not appearing in those petitions. He is appearing in only
Yes.
one petition, that is tender. But he is addressing the arguments in other two petitions, which was addressed by the council earlier. I don't know.
Our
why-
duty to impress upon the honorable court the facts, my
What
lords.
interest he has,
Please.
I don't know.
First one is 1 over and first one
Yes.
said, my lords, first petitioner, contract is able to get it, my lord, withdrawn. First one, your lords rejected the prayer for rejection, withdrawal.
But we have postponed our understanding to next time.
There are reasons.
That puts a correct full stop to us, my lords.
So no use in addressing. You can file before that. Any learned advocate can file, but before the date. File it before, on or before Tuesday, so that.
Great.
Green bench matters, still number 18, Mr. Anirudh Anand.
you remember.
It's petitioner, my lords, has made an application seeking grant of quarrying lease for building stone. Pursuant to that application, my lords, the technical report of the Department of Mines and Geology have recommended that the lease can be granted in favor of the petitioner. Similarly, my lords, the Assistant Commissioner of the Revenue Department has also recommended grant in favor of the petitioner. The Range Forest Officer, my lords, of the Forest Department, he's also recommended that there's no afforestation in that area and the land can be given to the petitioner, since there are other quarrying lease areas in the very same survey number where the petitioner has made an application. Now, only the DC and the DCF, my lords, are yet to issue the NOC so that the quarrying lease deed can be executed in favor of the petitioner. My lord, to take page 103, my lord, annexure D, this is the joint report prepared by the Revenue Department and the Department of Mines and Geology. Annexure D, my lords, at page 103, this is the joint inspection report. Page number 103, my lords, is the translated document.
Yeah, what is that?
This is the joint inspection report, my lords, carried out by the Revenue Department and the Department of Mines and Geology. My lord should see at page number 104. Very categorically, they say this land is not a forest land and the lease can be granted. And the stone which is available in this area is suitable for manufacturing M sand.
Where it is stated?
Please, my lords. My lords should see page number 105.
105.
Please, my lords, of the very same document. At the bottom, my lords, the last paragraph. As per Rule 8.5, submitted the proposal to the Honorable Deputy Commissioner along with the opinion held at the time of joint spot inspection that as per Rule 6.2 of the Karnataka's Minor Mineral Concession Rules 1994, stone mining can be allowed without causing any disturbance to the surrounding villages by maintaining a distance of 100 meters from the public structures and using controlled projectiles. This is a joint inspection by the Revenue Department and the Department of Mines and Geology. Similarly, my lords, Annexure E, the very next document,
So why they are, despite this, they have not granted?
they have not issued NOC, my lords. The Deputy Commissioner and the Deputy Conservator of Forests, based on these recommendations, have to issue NOCs to the Department of Mines and Geology.
Lord, I'll take notice and file my objections.
Notice written on 4th November.
Grateful.
Additional government advocate, Srimati Neelofer Akbar, accepts notice on behalf of responder one, so and so, to further state that before the next date, statement of objections, come affidavit in declaration by file.
Adopt the date, my lord.
Date is 5th of November.
Grateful.
Number 19, Mr. Shukumar KB.
Nobody is there after it. None present for the petitioner, stand order. 7th November.
20 agents, seal number 21, it's a writ appeal. Mr. Manjunath,
My lord, this is respondents for writ appeal, my lord.
Delay.
Yes, my lord, 352 delays.
So delay we can't do.
352, yes, my lord.
Yeah.
Don't have a
My
copy.
lord,
352.
yes, my lord,
So
I am an agriculturist, I do not know the. legal
notice
procedures.
written.
Okay.
6th of November.
22 agents, seal number 23. The Sarojini Muttana.
But the
Yes.
writ petitioner,
But delay is there.
I'm sorry, delay, is there delay? There is.
Technicality can't be overcome. Some technicality. So you are appearing?
Please,
Then we'll condone. If everybody is appearing, then we can condone it.
my lords, insofar as my lord delay of 27 days, my lords, I cannot.
No, provided all are appearing.
My lords, I am the only.
He's the sole respondent.
All respondent.
Please,
So write down. Third learned senior, third learned advocate to the parties, upper make a appearance, all names. Delay of 21 days in filing the present writ appeal is sufficiently explained, is adequately explained in the supporting affidavit along with the application for condoning delay. Sufficient cause is made out, delay is condoned, application is allowed. Now appeal, let us see what is the appeal.
Please.
You are the appeal.
No,
You are the.
I am for the appeal. Lord, the writ petitioner was appointed as scientist F in the appellant organization called Aeronautical Development Agency, which is a body which is under the administrative control of the Ministry of Defense. He was appointed in 2011 and he was discharging duties as a scientist. About 3 years later, my lord, on 29/4/2011, his post was converted to that of FTE 14. 31/1/2014, his post was converted because there was a need for some flight test engineers. So 3 years later, we converted it with effect from 31/1/2014 as flight test engineer. And then we wanted him to go to a shore-based test facility at Goa. He did not go. Then we deputed him to another entity called the DRDO. There also he did not go. Eventually, the Air Force and Navy found their own flight test engineers. There was no further requirement of continuation of the flight test engineer. So we took him back in the fold at ADA. Subsequently, he sought for promotion from FTE2 to FTE3. The requirement under the rules was that he should have completed 5 years of residency. Now, his 5 years of residency commences from 31/1/2014, when his appointment was converted to that of FTE. Now, what he says, his contention is, and which the learned single judge has accepted, is that his residency will commence from his appointment as the scientist. No, that is not permissible.
Appointment is?
Appointment as scientist, his original appointment as scientist in 2011. The learned single judge says that it should relate back to 2011. That is the first error that the learned single judge commits. And then, my lord, for his promotion, the recruitment rules provided for an interview by the assessment board. Lord, for that, there are certain recruitment and promotion rules 1990, which is available at page 176 of the volume 1 of the writ appeal. Would your lordship have one look at the relevant rule? Page 176, my lord, is the recruitment and promotion rule. In these rules, 6.4 would be relevant for your lordship's consideration, which begins at page 189. This is for his consideration of promotion from FTE2 to FTE3, for which 5 years residency was necessary. Lord, page 189. Departmental promotion shall be made amongst the officers possessing the experience as given in Schedule 4 and serving in the next lower grade. Selection of officers for promotion shall be made in accordance with the following manner on the basis of individual merit. A, assessment board as per Schedule 5 shall be convened once a year. B, the first step in the assessment process is screening by a committee appointed for the purpose. The guidelines for screening will be prescribed by Director General ADA from time to time. Those screened in will be eligible for further assessment and interview. If an officer declines to appear for the interview, this may not be relevant. D, all scientists / engineers of the society who have completed the prescribed number of years of service in the grade shall be eligible for consideration for assessment for promotion to the next higher grade under a flexible complementing scheme. E is relevant. In evaluating the suitability of the officers for promotion, the assessment board shall take into consideration their performance, merit, seniority, etc. as applicable. The selection shall be on the basis of a written test / skill test wherever prescribed, confidential report and interview. The assessment board shall draw up a list of officers who are assessed as fit for promotion to the next higher grade. Lord, the assessment board met and it assessed. Lord, would your lordship for a moment take up this volume number 2? In volume number 2, I have produced at page number 436, I have produced a document which discloses how that committee is formed. Please have a look at the officers who constitute that committee, very senior officers of the chairperson is the Director General Aero, page 436, Lord. An office order regarding constitution of the Committee for Assessment of FTE2 in ADA. It is dated 20th September 2019. Based on the approval of Director General ADA, Secretary Department of Defense R&D, and as per the scheme of FTE FTP policy of ADA, the following committee is constituted for consideration for promotion of eligible flight test engineer 2. Director General Aero shall be the chairperson, PGD CA and Director ADA the member, Project Director FT NFTC ADA member, and Commandant AST as the external expert. Please have a look at the next document which gave the APAR ratings, may not be necessary. Would your lordship please have a look at the assessment sheet at page 439. There were 2 officers who were shortlisted, who were considered for the promotion. At 439 is the assessment sheet of another officer. His name was Captain Maltish, which your lordships will find in Group Captain Maltish at line number 3. And please have a look at his interview marks somewhere in the center. Interview marks obtained, that is 92. The minimum marks required is 85, as can be seen on the left-hand side. And in the center, it says interview marks obtained is 92. And then the recommendations of the board is fit for promotion, can be considered for so-and-so, so-and-so, subject to residency. Now, on the next page is of the writ petitioner, page number 440. The assessment sheet, the assessment as made by the assessment committee. The writ petitioner's marks are 81 as compared to 92 by the other group captain. And the recommendation by the board, Lord, I will read you for your lordship's benefit. It says not fit for promotion. And Lord, this assessment is made by a body of experts. Lord, the question, Lord, is can the learned single judge replace the wisdom of this body? He just ignores this and he says they should not have done so. He says the moment he secured 85 marks, he should have been considered. And he promotes him to not only to FT3, but to FT4 as well.
First, my lords, I'm afraid, my lords, what have been submitted, my lords, unfortunately, my lords, senior counsel is not briefed properly. But the issue is this, my lords, I was working with, my lords, Navy earlier. I was the flight test engineer, my lords, at Navy. I was deputed, my lords, to aeronautical